We were able to roll up that company into the group this client held, and we then sold. And actually, we sold it on an earnout and over 4 years.
As you plan your exit, thinking about tax well in advance, how you can, set up your structures to be efficient and cost effective makes a lot of sense.
If an exit is something that you're thinking about, there are also ways that you can structure things well in advance so that you can minimize tax. There are ways that loan accounts are raised legitimately, lawfully, such that part of the purchase price comes in the form of the loan account rather than the shares.
The goal with Exit Strategy is to create an educational platform that helps business owners and founders develop skills that will help them get their businesses sold. Welcome to another episode of Exit Strategy Secrets, the show where we help business owners get the best insights to prepare their businesses for an exit. We actually hit a great milestone, got over 500 plays on Spotify and some really great feedback from the listeners. So please give us a rating on Spotify. It really helps. And today's episode, we're actually shifting away a bit from talking about successful exits, and we're speaking to an M&A expert lawyer, Stephen Good, who's going to give us some great insights into the legal process of selling a business. So a little bit of background on our guest today. Steve is a seasoned commercial attorney with a passion for long-term strategy and big picture thinking. His fascination with the future led him to earn a master's in philosophy, specializing in future studies, allowing him to offer more insightful and contextual advice to his clients. Steve has a strong focus on negotiation and is also an internationally accredited mediator who believes litigation should always be the last resort. He provides strategic and commercial guidance to his clients across diverse sectors, specializing in high-stakes transactions, often representing sellers or companies seeking investors. Steve gets inspired by his entrepreneurs that he advises, and he thrives on playing a pivotal role during the transformative moments in their careers. He's not only an advisor, but also an investor, having backed some of the early-stage companies he works with. His journey includes the highs of successful exits and valuable lessons from ventures that didn't go as planned. Beyond his legal expertise, Steve sits on multiple boards and in his free time enjoys reconnecting with nature and exploring new places, especially Italy. Welcome to the show, Steve.
Grazie. Great to be here. Thank you very much, Aaron.
So, Steve, just to kick it off, maybe you can share a bit about your background and how you became a specialist in M&A law.
Sure thing. So first of all, it was to select law as a career, and I was always drawn more towards the numbers, and I was a keen reader from a young age, and I'd read newspapers and my dad's financial periodicals, and law seemed always to feature strongly. So my pull to law was quite natural, and then it was, well, which area of law post my law school, post graduating, which area of law kind of can I make the biggest impact in through my actions? And to me, the options seemed either human rights, and at the time I was studying, South Africa was going through massive transformation. We had a new constitution, so that was a real contender. And then the other was, well, commerce, because so much of what happens is down to commerce and the possibilities allowed by the legal entity that is the company. So in the end, I chose the corporate route, and I did my articles with an out-and-out corporate law firm, and that was me then on the track of transactional work and M&As, and that was almost 20 years ago. Yeah.
So, Steve, how many transactions have you worked on?
I've never tallied them up, but I would guess it's could be into the hundreds, quite conceivably. Some much smaller, some much bigger, some that have closed, and some that haven't. So yeah, I would think into the hundreds.
Wow, that's incredible. So
Yeah.
just so everyone knows, the way that Steve and I met when I was raising capital for our experience, and we got to the latter stages when we got issued a term sheet. Steve came on board as our advisor, and I knew nothing about term sheets, shareholders agreements, subscription agreements. And I remember going through the first term sheet with Steve and going, "Geez, like, I don't understand any of this stuff. Can you give me a crash course in
Yeah.
law?" So the term sheet is actually such a critical component of the M&A process. So maybe you can just give us a little bit of context as to the importance of this document and why it's such a critical thing to understand.
Yeah, I agree fully and think that you can't overstate the importance of the term sheet, even though it does come quite early in the transaction. So typically, the first two documents that you'll sign with any party that you're going to transact with, whether it be an investor or a buyer of your company, and as you said in the intro, I generally act for sellers. The first document you're probably going to sign with that third party will be an NDA, a non-disclosure agreement, which maybe if we get time we can chat about that too, because that, to my mind, is also not something that you should just take a template and present to somebody. There's
Right.
important protections in that document. But then is the term sheet. And the term sheet, why sometimes parties can not fully appreciate its importance is the nature of it is for the most part non-binding. So, which means that either party can walk away from the document without the other having any recourse against it. But the fact that it's non-binding is certainly not a reason not to spend a huge amount of time and effort in negotiating the document. And I'll tell you why. First, it's the content, and we'll get into the content, but also, and let's use the example of you being a seller. So this is the first time that as the prospective seller that you getting a chance to put your best foot forward. So you're setting the tone of what's going to be the tone for the duration of the contracting phase, the negotiation, and also in all likelihood there's going to be a relationship post the transaction. So this is an important time for you to show them who you are in the world, and also for you to get a good sense of them, the buyer, and critically how serious they are about this deal, because any kind of transaction is incredibly taxing. It requires a lot of your attention and focus and occupies your mind, and can be very distracting. And to a business owner, that's a real problem. So what you don't want to do is have a purchaser, a half-hearted purchaser who's basically taking a look but is not entirely committed. You want to assess their commitment levels by negotiating the term sheet heavily and getting a better read on them. And then finally, the other reason to spend a lot of time on the term sheet is, although it's non-binding, it's very difficult to revisit terms that you signed off on. So my advice always is treat the term sheet as close to a real agreement as possible, and don't leave gaps, because as soon as you signed it, the portion that is generally binding on a term sheet is the exclusivity.
Right.
So you give the buyer or the prospective investor an option, in a sense, on your business for the duration of the exclusivity period, and during that time, you are responding to their requests and doing all you can to facilitate things. And if they do walk away after that period, first, it can be quite demotivating for you, and also word kind of gets out, and questions are then asked. Purchaser X was looking at the business. They had an exclusivity period. They went quite far, but they walked away. And often that doesn't reflect well on you, rightly or wrongly. So to summarize, term sheet, incredibly important document that you should negotiate heavily and sign only when you are satisfied that the essential terms are there.
Yeah, no, that makes perfect sense. So we've recently partnered with Kaya Creative Studios, who are just helping us put this whole project together, making it seamless for us.
Partnering with Kaya really feels aligned to our mission and our integrity of our brand. They really do have a full array of podcast-related services and products. The Kaya team have the experience, they have the insights, they have the understanding and the full medium to really help a brand kind of grow.
If you're listening to the show and you're interested in starting a podcast or making it part of your branding marketing strategy, you should get in touch with Kaya. It's an excellent service. Hope to make some amazing content out there. For those of the listeners who are unfamiliar as to what exactly a term sheet is, can you walk us through the typical structure of a term sheet?
Sure. So what it does is it sets out the key terms of the transaction that you're doing. So if we assume we're going to talk about let's say a 100% exit of a business. So you're selling all your shares in that business. What the term sheet will do is record that it's a sale of shares. It's a sale of 100% of the shares. It'll set out how the payment price is going to be paid. Is it going to be paid in cash? Is it going to be paid in shares? Part cash, part shares. When is it going to be paid? It'll set out whether it expects you to stay on as an employee, what terms may apply to your employment. So it's obviously depends on the transaction, but it's all the key terms of whatever deal you're doing. In the context of a sale, it's including things like representations and warranties. Those are where the purchaser looks to you as the seller to attest to a certain state of affairs existing. It's a way that the purchaser allocates risk. And why I say to you that it's so important that all the details are teased out in this document is there is a big asymmetry in expertise and experience between you and your counterpart. Again, I'm assuming I'm acting for the entrepreneurial guy, because the purchaser has done this many, many times before.
Right.
And so understands this domain very well, and also therefore understands things that are not apparent to you as a person who's coming to a term sheet for the first time. I'll give you the example. In the purchase price, there are many things that need to happen before a stated purchase price in a term sheet actually translates, drop down all the way to the money that the seller gets. So they're what we call purchase price adjustments. Things like, for example, the purchaser, and it's usually the purchasers who present the first draft of the term sheet, because they're making the offer in a sense. So they will say in that offer, we're buying your shares on a cash-free, debt-free basis with adequate working capital. Now, adequate working capital is quite a fluid concept and is used by seasoned purchasers as an effective price adjuster. So to an inexperienced seller, the number that they see on the document, if they're not properly advised, when they see the differential between that and what they actually get, it can come as quite a shock. So there are many details that need to be teased out properly to be before I'm comfortable for a client to sign off on a term sheet.
Right. I'm actually looking at the term sheet that I signed, when I went through the fundraise, and it's actually quite a long document. It's about 5 pages, and it's got quite a lot of terms in it. Actually, it talks about how the board meetings will run, what the board can do, restrictive shareholder provisions,
Yeah,
preemptive rights.
because your one was bringing on an investor, so there's going to be a longer term relationship
Right.
between you and the investor as opposed to an out and out exit. So there are lots of terms to hammer out, and you'll remember it took us a long time. And I
Yeah,
just say,
okay.
from the key terms, the other important thing that a term sheet, in my view, should always include is the process from here onwards. So you sign the term sheet, and let's say you as the seller, as the prospective target for investment, you give the third party a 60-day period of exclusivity. Then what you want to know is, right, what happens the day after I sign the term sheet? And what I like to see in a term sheet is a timetable. So for the purchaser to say, well, we will commence our due diligence within 5 days of signing. We will present you with the drafts of what they call the definitive agreements, the long form agreements, within such a period. We'll commit all the resources we need to doing this deal as quickly as possible. Because the one thing that is imperative in a deal is momentum. So as we said at the beginning, can be a very distracting process, and quite a anxious period. So what you want to do is move swiftly, go slow to go fast, so thoroughly, but keep the momentum up.
Right.
Absolutely. And the other thing is that things happen, that left field things happen, and that can scupper deals. So the longer you allow, the greater the risk of something happening that you could never have anticipated that could scupper the deal.
Can you maybe walk through an example of, when you were going through a deal and it kind of just didn't go well? What happened?
I've had a recent experience of a term sheet where we actually presented. We were the seller, and the first thing that was a little bit odd was the purchaser asked us to present the term sheet, which we did, and then there was very little feedback on the term sheet, which also was a bit odd to me. And the nature of the transaction was that this buyer was looking to buy just a minority stake, 40%. And what I anticipated then was that they would ask for lots of what we call minority protections. So rights which give them influence over and above their 40%. And none of those were really forthcoming. And also there was no path to control, which left me asking myself, well, why are they wanting to do this deal? And that's why I also like to include, I didn't here because my client wanted the deal to happen, but I like to include the strategic rationale. What's this deal about? Why are they wanting to do the deal? And so the long story, but it didn't happen. And they also were showing no urgency. And so that's an example of where, because we didn't know really what was motivating this third party, it ended up, there wasn't a strong motivation. And so the deal didn't happen. So that's something. But in terms of something from the left field that too much time can allow to emerge, a client of mine a year or so ago sold his business to an American company, and we were required to sign a document called a subordination agreement. I won't go into it, but from a bank that I'd never heard of, Silicon Valley Bank, and
Right.
and you may remember that Silicon Valley Bank kind of toppled over last year. So everything was on track for our deal. And then suddenly, because there was a problem with one of the biggest banks, I understand, in West America, suddenly the deal was put on hold. So, yeah, who could ever, if he and I had sat in a room for a weekend and said, what are the 100 risks of the deal not working? We would never have come up with, well, the buyer's bank may go under. I mean, so momentum and really a proper rationale for the deal. There must be a real strategic, motivating thesis. And then,
that is actually kind of a left field. I remember when SVB went down, it was quite big news actually, and it didn't really make sense. Yeah. So can you talk through a little bit about warranties? Because I remember, when I looked at the warranties, they were quite scary the first time you read, these clauses. So, what is the concept around warranties, and, how should a seller, understand them or negotiate them?
Yeah, so the challenge for the buyer is it's taking the seller at its word. So it doesn't know if you are in breach of a big contract with an important client. It doesn't know if you haven't paid your taxes. So it's got various ways that it tries to protect those risks. The first is it will do a detailed due diligence investigation, which usually happens. A preliminary one happens typically before the term sheet is signed. But then once the term sheet proper is signed, the due diligence really kicks off in full force. And so they do the due diligence investigation, and then they send this list of these representations or warranties. And they cover all the areas, and it is a long laundry list, as you say. But essentially what those are ways to adjust risk. So they're saying to you, you seller, promise me, in a sense, that your taxes have been fully paid up. The company's taxes have been fully paid up. Promise me that there's been no litigation, that you know of no reason why there could be litigation. And so it's a risk allocation of risk from them, but for the warranties, they would be taking on the risk, so they put them on to you as the seller. Because if it emerges after the deal that one of those facts that you warranted, so you say, at this particular point in time, this is the state of affairs. If that emerges to have been incorrect, then the purchaser can sue you for a breach of a warranty. So it's also a heavily negotiated area of the ultimate definitive agreements. But even in the term sheet, there are important negotiations that should be happening around the representations of the warranties. And for example, you may want to, as the seller, cap your liability. So know that your maximum exposure is a certain quantum. And so those are the kinds of things that you introduce in the term sheet.
Yeah, no, 100%. I just think it's interesting because when I was looking at those warranties, there were certain things that I didn't actually know, so I was like, I'm a bit nervous to sign this because I'm actually not 100% sure if this warranty could have happened or not, because it could be someone else in the company or, something I don't know about. So how do you actually navigate that?
Yeah, so I think you must not sign off on anything that you're not comfortable signing off on, would be the point of departure. So if you're not sure, you say as much, and then we can qualify the warranty. So we say, as far as the seller, Aaron, is aware, X is the case. And the purchaser's anticipating those kinds of arguments. and if they're well advised, and they will be because they experience in this domain, they will. There's back and forth between the lawyers, and then in the end you settle on some kind of middle ground, and then all the warranties are also qualified by disclosures. So you've got an opportunity to say, I've paid all my taxes, but I must disclose that I received the following notification from the South African Revenue Service relating to VAT for this period. And always my advice is, come completely clean. You don't want comebacks, and a good conscience is the best pillow. You want to sleep easy. So
Yeah.
if you're not sure, say that, hand up, and then your attorney can negotiate for you how best to word your uncertainty.
So, what are some of the most common mistakes that you've seen sellers make when signing these term sheets that could have been avoided if they had just had a little bit more knowledge about, how to go about this process?
Well, I think the biggest mistake would be trying to sign would be signing a term sheet without advice, because you don't know what could be in there, or should be in there in the context of your particular transaction. So there's nothing more frustrating for me than a seller who presents me with a signed term sheet, because I could have gone back and said, this is unacceptable. Why is that not there? If that's there, then this ought to be there. Because there are benchmarks and industry norms and things which the seller is going to be oblivious about through no fault of his own. So that's mistake number one, is not being properly advised.
Right.
Yeah.
Yeah.
And
Yeah, go ahead.
no, I'd say, and probably that's because the term sheet, because it's non-binding, the seller is under the assumption that, well, it's not that important, and I'll push harder when I get to the proper agreements. But as I say, the constant refrain when you're negotiating the full agreements is, but it's not in the term sheet. That's not what the term sheet says. And that becomes quite a difficult argument to counter.
Right. So, what are the key negotiation points in the term sheet for the seller? And, you talked a little bit about, how you really enjoy the negotiation process. What are the tactics that you use to negotiate with your clients?
So I am a proponent of the William Ury, Roger Fisher getting to yes school. And it's negotiation. I like to regard as it's discovery. So it's you are investigating, and what you're trying to discover is what, let's assume we're doing a sale, is what is really motivating the purchaser. And the purchaser, they're actually different persons that comprise the purchaser. There's the individual that could be championing the deal within the purchaser, and he or she has an agenda on its own, which you want to try and understand. Maybe they want this deal under the belt so that their next move in their career is advanced. The purchaser, and this also goes to valuation, value is in the eye of the beholder. So I'll give you an example. I was acting for some advertising agencies a number of years back, and there was a multinational that was in town kind of hoovering up agencies. And what we eventually understood was that the multinational was doing a huge deal with another multinational. And to that multinational, our prospective buyer had said, I've got Africa cornered and covered. So, but it didn't. But it was in the process of doing that. So once we knew that, well, now we can push incredibly hard because we know really what's motivating them, and they almost have to do this deal. So what you're trying to discover is what they call the BATNA, the best alternative to a negotiated agreement of your purchaser. So if they don't do this deal with me, what they're going to do. And so it's about really understanding their motivations. And then I like to say the way that you get your best deal is through committed indifference. So you've got to go all out to get this deal done. But if you can walk away and be indifferent, and obviously that's a very difficult thing to actually feel and really execute, but that's how you get the best deal. And at some point, your counterpart will feel it. He can feel Aaron really, really wants this, but also not that much, as to the point where he's going to give a warranty that he's not certain of. So, yeah. And then it's about listening, because you've got to ask these questions to investigate and dig and excavate and try and really get to the bottom of what's motivating them. But then you have to really be listening hard. And that doesn't come so easy to all of us.
Mm. Yeah, especially when you want to get a deal over the line, you get excited and you kind of like see a number and you're like worked really hard for it and you stop listening and just want to get it over the line.
Precisely. And I'm saying to you, you must be indifferent. And he's like, what do you mean indifferent? This is my life is all hinging on this. But it's actually not, for the most part. It's very rare that it's, and then just to go back one step, before you do that that negotiation with the prospective buyer, for example, you've got to really explore your own objectives. Like, what really, really, really do I want? And you may say to me, well, I want this number. But that number, I'd say, why do you want 100 million? And then you'll say, well, I want freedom and I want to do whatever I want. And then I'll say to you, well, if you get 150 million, but you have an earnout for 4 years and you have a purchaser whose reputation is not great and who's incredibly demanding, you're not going to have you're not going to have the freedom. You may have 150 million, but your freedom is going to be curtailed. And so you have to really properly understand your own motivations now and into the future.
Yeah, that's really interesting because it kind of brings me to my next point, which is like payment terms and earnouts. Because, if I was a buyer, I want to protect myself. Obviously there's a value that's on the table, but I would say, okay, well, I'm happy to pay this, but you need to achieve X, Y, and Z over the next 2 or 3 years. And if you don't, this will happen. And it's quite interesting because a lot of people I've spoken to, when they actually cross the line and they move into the earnout phase, it can actually be very stressful. And that period of time while you're earning out, you always think like, did I structure that correctly? Why is this so hard? What is how does the earnout work, and what do you commonly see at this part of the term sheet?
Yeah, an earnout is a common structure, and it's a way of bridging the divide. You say, I want 100 million. The purchaser says, well, it's not worth 100 million today, but if you achieve your forecasts, then I'll top it up. So it's you earn out over time based on performance. So it's a de-risking mechanism for the purchaser, and it's a way that you can get the value that you want. The challenge, if we're sort of staying on the emotional dimension, the challenge for guys like you, entrepreneurs, is, with all respect, you're not necessarily always the best employees. So you're used to charting your own way and getting things done quickly and at whatever cost, and suddenly, having sold your business, you no longer have that autonomy. And that can be an incredibly difficult thing for a seller to come to terms with. So it's like your wings have been clipped. And I remember a situation where a client of mine sold his business and was in an earnout, and the first year went really well. And then he was a type of business owner who was very empowering of his staff, and everyone loved working at this business. And so they had a good year, and he said to the buyer, right, this is the bonuses that I want to be paying, and this is the percentage increase that I'm going to be giving the guys. I'm back, and the purchaser said, unfortunately not, because there's a global moratorium on any increases, because globally we've had a bad year. And so this guy could not believe that even though we'd done a lot of work on the agreement, we weren't able to push that through. And I reminded him that we tried at that point, but it was something that we'd sort of said, well, it'll never get to that. And so the earnouts, yeah, it's a difficult thing. Also has to be very carefully negotiated, and even negotiated again back into the term sheet, because things like if you sell to a big company, a big group, they want things standardized. So they'll say to you, well, you will be using our auditor post the deal. You will be using our IT guys. And now those are going to be at higher costs than you've run your lean operation using up until that point. So what I will be doing as the attorney is negotiating that any excess, any differential is excluded from when you work out the earnout payment. So there's many details. I would just make this one point. Again, going to ultimate motivations, why are you doing this deal? Personally, I advocate against ever agreeing to a profit warranty. So, because there are too many variables, and so I wouldn't want my seller client to be warranting that a certain profit will be achieved in a year's time. There are just too many things. When COVID is the obvious example, things happen that are out of your control, and you want your sale to be such that you don't have those kind of concerns. The whole point is that you've done well, been rewarded, and why take on that additional emotional uncertainty? So I always say, your first payment, is that going to be enough for you? And you should be saying to me, I can live with that. And then the rest is just top up upside.
I see. Now that's super interesting. And when you see a term sheet, when you're with your client, and what are some of the things that are like red flags immediately? You're like, no, that's a red flag. We can't have that. And what kind of things do you see that come up like that?
Well, yeah. So profit warranty for sure for me is a red flag. Anything where you can be painted into a corner, forced into a corner. So a put option, for example. So that's where your investor says to you, I'll invest so much, you give me X%, and then if in 5 years we haven't exited at this minimum price, I can put my shares, I can force you to buy my shares at this using this predetermined methodology. So, yeah, something like that, I don't really countenance, because to the point, there's so many things that can happen, and this deal, you don't have to do this deal. So why accept that type of potential demand being placed on you? I saw one recently where, even worse, it was a put in dollars in a South African context, which meant my client accepts the risk, the currency risk. So if you sort of translate that to how it may eventuate, you could have a brilliant performance in rand terms, and suddenly at the end of the 5 years be presented with a put in dollars, and if the rand has fallen out of bed, your future's in jeopardy. So things like that are red flags, obvious red flags to me.
Thanks for sharing that, Steve. I think that's really helpful. So just to give a seller context on the full legal process in selling their business, I know we focused quite a bit on the term sheet, but what is the entire sort of step-by-step legal process from, okay, you go out, you find a buyer, what are all the legal steps to actually getting this over the line?
Yeah, so assuming that we've got the key terms laid out in the term sheet, so we've agreed on things like valuation, we've agreed on the purchase price, we've agreed on how the purchase price is going to be paid in cash or in part in shares, we've agreed whether there's an earn-out or not, we've agreed on the risk allocation in terms of the warranties. Then there's a due diligence process that usually follows the term sheet signing. Very often the buyer will enlist professionals to do the due diligence. So they'll do a due diligence, a legal due diligence. They may do a tech due diligence, they'll do an operational due diligence, trademark or IP due diligence. And at the same time as that due diligence is happening, we'll be negotiating the long form agreements. And the long form agreements also will be informed, the warranties and the representations will be informed by the results of that due diligence. So the lawyer may say, I've seen this and I'm worried about this situation. And so that'll get inserted into the contracts. For example, what is often not properly appreciated at the time you sign a lease is a common clause in a lease is what's called a change of a control clause. So the clause says, if you, company X, if there's a change in your shareholding of more than 50%, then that's deemed to be an assignment of the lease. It's deemed to be that you're making over the lease to a third party, which means you need our approval, the landlord. So the lawyers, when they're doing the due diligence, the legal due diligence, will pick that up. And that then becomes a condition precedent, a suspensive condition to your deal closing. So suddenly, a small landlord in one of your small branches could slow down and even potentially frustrate the deal from actually happening. But then, assuming that we negotiate and we sign the definitive agreements, then there'll be some suspensive conditions. Some are things like there could be a competition commission involvement, other regulatory authorities. Maybe the buyer needs to speak to one or two key customers, and then the deal closes. Once those are fulfilled, the deal closes, and then the money changes hands.
Okay.
Right off into the sunset. Yeah.
And do you have any experience sort of like on the on the tax side of things, or is that more relating to accounting?
No, I mean, I think that the tax is, I do have experience of the tax, because the tax is such an important part of the deal.
Yeah, exactly.
So the whole time, and from an early on, you're thinking along tax. to go back to the earnout example, what you don't want. So generally, when you're a seller, you're paying capital gains tax. So which is the difference between what you get for your shares and what you paid for them when you got them originally, which is often a nominal value. In the earnout context, what you don't want is to be hit with capital gains tax on money that you haven't yet received.
Right.
So if there's an unconditional payment coming in a year's time, 2 years' time, then you as the seller become liable for that, even though you haven't received it. So as the lawyer, I need to be very much alive to tax considerations. And even if an exit is something that you're thinking about, there are also ways that you can structure things well in advance so that you can minimize tax. So while you pay tax on the shares, an asset that sellers often also have in the company is a claim against the company. It's a loan account. And so on a loan account, you're not paying tax. So there are ways that loan accounts are raised legitimately, lawfully, such that part of the purchase price comes in the form of the loan account rather than the shares. But
yeah, that's actually really interesting, and that's probably a whole podcast episode in itself. But I think that definitely gives a lot to think about, because I think, as you plan your exit, thinking about tax well in advance, how you can, set up your structures to be efficient and cost effective, makes a lot of sense. It's not something I have much experience in, but it's definitely something I want to learn a bit more about. So, Steve, you mentioned that you often invest, you're quite entrepreneurial and you invest. I'm not sure if it's with your clients or just generally, in companies. Can you talk a little bit about, that passion of yours and how it's going?
Yeah, so if I think back to the very first time I did invest, and it's always been with a client of mine. So someone who I have confidence in and who has a track record of success. And so the very first one was this client of mine who'd exited 2 companies, and I advised on those exits. And then he said to me that he'd been approached by some guys who wanted him to financially put up some cash, and then they would run this business that he would then be invested in. So he said to me, if I could negotiate the terms, and my fee would in effect be paid by way of shares, was I open to that? And I was. And so that happened. And then probably 2 years after that, we were able to roll up that company into the group that this client held, and we then sold. And actually we sold it on an earnout and over 4 years. And so for a fee generating attorney for the next 4 years to suddenly just receive a check for work that I did a long time ago was incredible. But in hindsight, it was almost not a good thing what happened to me, that because I started to believe it was easy. So the next investment, which and a lot of my winnings from the first one are then put into the next investment, and that went exactly the opposite direction. So we lost everything there, and that was incredibly frustrating. And looking back at it, I kind of liken it to, because there were 5 of us who invested at the same time, and they were all successful entrepreneurs who'd all exited companies, and then me alongside them. And it's like if you're at an airport and with a whole lot of friends, and you're going to catch a flight, and everyone's thinking someone else is thinking about when we have to board, and then you miss your flight. And so all of these guys there, I just, I think we all thought, well, he's obviously vetted it, and it makes sense. But truthfully, if we'd really done proper due diligence, we wouldn't have invested into this company. And so anyway, that company is no longer around. So we lost everything there. And that was, especially for a fee generating professional, very, very hard pill to swallow, because then I thought, post-tax, all that work, just like that, up in smoke. So that sobered me a lot. And then since then, I've made a few other investments, and one that I'm currently invested in, which is going great guns. But everyone is a lesson. People, we're all different and have got different motivations and behave differently in different contexts. So I'll give you one example where I, together with another colleague, invested in a business. He's a business broker, a wonderful software development company, but what held them back was, I would say, over delivery. So they were so good at what they did, they never lost a single client, but because they were perfectionists, they couldn't really grow as much as they otherwise would have. So they could have done a kind of a very good product, and then moved on. But she just kept on fine tuning, and so it was a frustrating, almost an opportunity lost. It was a good investment, but and I take nothing from her. Whoever was lucky enough to be her client was very lucky, because she was fastidious and so good. But yeah, so we could never have known that when we invested in it, and then you learn. And other people in the deal context are not people who can say que sera, whatever will be. They're not like that, so they get much more grasping. And then if you just the investor and you sense that in your propeller of the company, then you've got to let them do the deal, because otherwise, who knows what's going to happen. So yeah, it's been very interesting, and I love it, and I like to think it means I can advise better, because I know what those warranties mean. I know what they mean.
Yeah, that makes sense. Actually, that really does make sense. So, like we're kind of getting towards the end of the episode, so I thought it might be nice. You've got a lot of experience, with transactions. You've seen people sell businesses, raise money, etc. What comes to mind in this closing statement as like just key advice for business owners that are kind of starting this journey, thinking about the exit? What is your advice to them as they begin this process?
I think you've got to be very clear on your objectives. So in the context of investment, I think I like to talk about, you say to your prospective investor, I'm looking for X, which is a number, and a contribution from them, which will enable me to do Y, which will translate into Z. So really clear on your objectives, because that means that you can then filter out your potential investors. On the investors and even the purchasers, I'd also say money has got a personality, and you need to understand exactly what comes with this money. Where's it coming from? What are their motivations? What are their drivers? The purchaser, what's its reputation in the world? Because that's going to impact on you. And then if you do a deal, and let's say it's an exit, I think take your time in spending the money, because we are affected by a sudden injection of cash. It's for most of us, an alien experience. And so just park it somewhere safe and don't do much for some time. Don't go and buy a big house, and or even worse, invest in something immediately. Take your time and get used to seeing that kind of number in your bank account.
Yeah,
And
no, that's
just be
great
more
advice.
considerate.
It's kind of like the athletes, when they make a lot of money and then they stop being athletes and they spend all of their money in a couple of years, and then they don't know
Exactly.
how to make money again. No, that's great. So, Steve, how can someone get in touch with you if they want to get your services or get have an intro call?
Sure. So the consultancy that I advise through is called Zeppelin Advisors. And I'm at Stephen@zeppelinadvisors.com.
Great.
Yeah, so
Yeah. So I mean,
I'd be happy.
I can highly recommend Steve. I've worked with him personally, and if you want to just have a coffee, I'm sure he'd be open to it. But thanks, Steve. Thanks for sharing all that knowledge with us today. It's very, very insightful. Not a lot of people are talking about it, and I think business owners, going through this process will really get a lot of value from what you've shared today. So thank you very much for coming on and being a guest with us.
Thank you, Aaron. It's my pleasure. I've enjoyed it. Thank you very much.
Thank you.